Hello, this is Elliot Schlissel, estates lawyer. Today we're going to talk about what do you do if you feel a will is improper or invalid. And what you need to do in that case is you need to contest the will. Now, there is a process in New York called the probating of a will. And when the will is probated, it is presented to a court, and individuals get to come to court on the return date for the probating of the will and advise the judge they seek to challenge the will. Now, what basis do you have to challenge a will or set a will aside? Well, the first basis is that you can claim the will was not properly executed. For a will in New York to be properly executed, it must be signed by the person making the will. It also must be signed in front of two witnesses who do not receive assets under the will. At the time of the execution of the will, all the parties, the witnesses, and the person making the will must be in the room at the same time. And the person making the will must state, "This is my will," or indicate to the witnesses that he or she is making a will. A second ground for challenging a will is claiming it is a forgery. A forged will is a will executed by someone other than the person who is supposed to be making the will. With wills that are prepared by lawyers, it is very difficult to allege forgery as a defense. Wills that are not prepared by lawyers have a greater potential of being challenged as being forged. A third reason to challenge a will is called lack of testamentary capacity. In this case, you basically are alleging that the person who made the will was incompetent on the day the will was executed to make the will. You can allege the person has Alzheimer's disease, dementia, there was mental illness, he was taking prescription or non-prescription drugs that prevented him or her from knowing what he or she was doing at the time the will was executed. A fourth ground for challenging a will involves either undue influence, fraud, or duress. In each of these situations, the individual making the will may have been deprived of his or her independent ability to make reasonable decisions with regard to what was to be in the will. Now, probate. The purpose of probate is a process to determine the validity of a will. When the will is sought to be probated, the grounds I referred to previously can be argued to set the will aside. Should you have questions concerning the validity of a will or challenging a will, contact us